Maybe not, but today's guest is attorney David Green. We have some burning questions for him related to COVID-19, related to all the new laws that came out last year in New York State for tenant and landlord. So welcome, David. Thanks for coming on.
Rock, very much appreciate the time that you took to set this up, and hopefully through today's podcast, we can answer some of these burning questions for the landlords and clients.
Yeah, I appreciate it. I appreciate you coming on for sure. So my first question is just, can you give a little origin story, who you are, a little background?
Yeah, absolutely. I'm a private practice attorney in the Tri-City area. I'm based in Colony with offices also in Albany. I've been an attorney since 2001. My practice started off heavy in accounting type areas with estate planning, elder law, trusts of that nature. And I, over time, have gravitated to including a very large landlord tenant practice, a lot of residential and commercial transactions. In addition to being an attorney, I also practice a good amount of accounting with taxes for my clients, as well as acting as a real estate broker. So kind of found a niche here, and landlord tenant seems to always be a reoccurring theme these days, never more than with COVID-19. And I think that's an actual pretty good segue into what are we facing today with COVID-19. And in New York State, so for anyone watching this outside of New York State, stop watching now. It's not applicable. We have three governing bodies that have provided laws, so to speak, for the time being during this pandemic. The first one, obviously, is the governor of the state of New York. Cuomo has put a stop on all warrants in the state of New York. So anybody that was in the pipeline, was about to get in the pipeline, or was at the end of the pipeline, everything was brought to a halt. And the order from the governor's office is very clear. No warrants can be executed upon until June 20th or after. So what that means is, if you had a warrant and you were waiting to do a lockout, if you had an upcoming court date, whatever the case might be, is nothing can happen until after June 20th.
Yep.
So that's the first piece of the puzzle. And that was doable, but then we got more bad news. For landlords, that is. The chief judge halted all filings in the state of New York, specifically the third district where we are. The courts cannot accept any new filings at this time, and there is no end date to that. That is a to be determined. We're hoping with the news today from the governor's office that the easing back into our reopening, that by June 15th, the courts will be open to file and take new cases. But again, that's subject to the chief judge's approval. I think the chief judge will very much be in line with what the governor said. So the hope is, as of today, that by June 15th, the courts will be open, if not sooner, to at a minimum receive new filings. The problem, though, is this third prong, this third law, which came into effect through the CARES Act. When President Trump signed the CARES Act, there was a moratorium put in place for all pleadings, and we'll get back to a definition of pleadings in a moment. There was a moratorium for at least 90 days for all pleadings against any tenant or landlord that resides or owns a building that is backed by a federal loan. So any landlord that has a loan through the VA, Freddie Mac, Fannie Mae, any federal money that backs that loan, were prohibited from serving any pleadings against any tenants in those premises. Here's the problem that presents. If we can't file a 14-day notice, then we can't commence an action. And the 14-day notice we'll talk about when we get to some of the new laws. Currently, in the state of New York, in order to commence a non-payment proceeding, you have to file the predicate notice, which is a 14-day demand notice. We are unsure, as we sit here today, whether or not a 14-day demand notice is or is not a pleading. So it would not be prudent on my part as an attorney to advise people to file any 14-day notices prior to the expiration of that 90-day moratorium, which is June 20th. If they did in fact serve it and it was later relied upon in an eviction proceeding and it was deemed to be a pleading because it's a predicate notice, there could be some very steep fines. So if we take these three governing bodies and we put them together, here's what we're left with. Under COVID-19, we shouldn't be taking any action with any of our tenant matters until June 20th or after. Okay, and when that day comes, then we can start considering how we're going to proceed. Now, naturally, if any of these three areas of directions change and they're lifted sooner, well, then we'll revisit. But right now, the safe play is June 20th and after is when we can start ramping up and serving our notices. Keep in mind, however, that you as a property manager, or you, if anyone's watching as an independent landlord, certainly have the right to communicate to your tenant and advise them, hey, look, you're in breach of your lease agreement, and that when the time comes, if that breach continues, we will take action. There's nothing forbidding you from giving them a reminder notice that some money was due or that they're in breach of some portion of the lease and that they should do their very best to become in compliance so that they can avoid any future court proceeding. There's no ban on communication. There's just a ban on any pleading. And at this point, in order to play it safe, that includes any 14-day notices. So we can't start the preliminary notices, at least in my practice, because I don't want to get in trouble, until June 20th or after. So
let me
that's
ask you a question.
Certainly.
Let me just ask you a question. So we've seen the government, give us pieces of stuff. So they say 25% of people got to stay home. Then it goes to 50, and by the end of the week, it's 100. So things just keep changing. It seems like they don't want to tell us everything up front, and then eventually they tell us. So my thing is, are they just saying June 20th, and then this date changes, and now it's July 20th? What do you think about that?
Well, I wish I had the crystal ball in front of me.
Yeah, I know.
I bet you Governor Cuomo and President Trump and the Chief Judge had that same crystal ball, because as it stands right now, as we start to reopen, I think we face two things. Number one, we monitor the health of the nation and New York State specifically. If there's a change in those numbers, then certainly it's going to go backwards. If there's a bump up in the cases, by all means, there's going to be they're going to claw us back to where we are right now and quarantine us. The second concern I have with it is, once we do open back up, will the chief judge implement certain restrictions as to how many court proceedings are going to be heard per day, per attorney? They're going to give us more time to allow us to get in and out of the court, or is it just going to be, hey, the court's back open, everything is back to normal, just make sure you wear your mask? I don't know exactly where we're going to fall, but there's going to be an overload of court proceedings and new matters being commenced that I'm hoping what happens is they bring all the court staff back middle of May, by June 1st at the latest. They're in the office for a significant period of time before anything new is commenced, so they can just get caught up on the backlog of everything that has to be reassigned, so to speak.
Yeah.
And by June 15th, when I think is the latest date that the governor spoke about today as being the date that everything should be reopened. So by June 15th, I think that's our target date, is, hey, the courts are going to be back open. We're going to be able to start filing thereabouts or soon thereafter. But keep in mind, if we haven't done any of our, for new landlords, or for new matters by landlords, if we haven't done our predicate notices, which we can't do till June 20th or after, we're not filing anything until after it's served at the end of June. The 14 days expires. So we're kind of in a catch. And any old 14-day notices that were served prior to COVID-19, we can still use those. But the problem is you'd probably be better off serving new ones before going to court at this point in time, because so many months have gone by, and many of the courts interpret the pleadings as whatever was demanded in the 14-day. If at any time the 14-day amount is paid up, then the matter is dismissed. It becomes moot. So people that served 14-day notices back in February and wanted to take them to court in perhaps March, but didn't get to file, That's a problem because they only demanded February and maybe possibly March's rent. Now we got April, May, June, maybe even July's rent. If they go to court on a 14-day notice and they pay the 2 months, then it's going to get kicked out, and then we got to start all over again. So
I got a question on that too. What if you have, so you gave a 14-day and you're like, I don't care about April, May, June. I don't want to start all over. I just want them out. So would you be better off to do the February and March, the 14-day you already done, and start there and not even do a new one? Well,
yeah, you know, if you have a tolerance for risk as a landlord and you really want a particular tenant out and you don't mind using some resources to pay for the fees to do so, then you have the legal right to proceed on that 14-day notice in January, February. Absolutely. In Albany, I would think twice in the Albany City Court, because the judges there have made a determination, although I don't agree with it, they've made the determination that if you can only plea for what was in that notice, and if they pay it, you know, legal aid jumps on that decision the judges made, and they get some cases dismissed. So, but if you have the inclination that the tenant will not pay or doesn't have the ability to pay, or maybe is already left and you're looking just to secure the warrant at this point in time, absolutely you have the right to proceed with that.
Okay. All right, great. I know it was a question earlier today. All right, cool.
So COVID-19, that's where we are with that. Stay tuned. Things are changing by the day. And I will tell you, there's some really, really strong lobbyist groups downstate for the tenants. It's, you know, I try not to be too biased, but hey, I know who butters my bread. It's the landlords. And I recognize that the landlords are put in a very difficult situation of not knowing what's going on. And it's very likely that they will be without rent for several months, if not 6, 7, in some cases 8 months. And that's a lot to swallow. I'm hoping that when we do get up and running and we can get back into court, the judges will certainly recognize the hardship, and there won't be any further delays. Stay tuned, because the governor and the chief judge and perhaps even the president with the CARE Act, they can extend any one of these moratoriums or you know, prohibitions, so to speak, at any time. So you got to stay current on your material. And one of the best things to do is, you know, subscribe to, you know, other podcasts, or pay attention to the news, or, you know, email your attorney or your property manager to make sure you have the most current information.
Yeah, definitely. Good advice for sure. Hey, David, thanks for coming back on. Appreciate it. I know you wanted to update us on the new stuff that came out last week from the governor.
Certainly. There's been one change, and the impact of this change, quite frankly, is probably going to be quite minimal. The governor came out last week and indicated that there would be an extended moratorium on lockouts for eviction matters of people that have been affected by COVID-19. So in other words, any individual in a non-payment eviction type matter that has a hardship and can't pay their rent due to COVID-19 related matters, the judge can then extend the lockout date to August 20th. Now, the impact that has, in my opinion, is quite minimal, because by the time that we get going and the courts are open back up, because of the new laws that we discussed previously and the timelines that are statutory, it's going to get us to that date anyway. If we start filing in July and there's an adjournment in there, and by the time a sheriff can get around to executing on any warrant obtained, we're at that date anyway. So when I say it's more of a, you know, a political thing, not that it's an intentional political thing, but August 20th does not hurt, in my opinion, the landlords much at all. And certainly it only applies to non-payment situations. It does not apply to holdovers, objectionable tenants, breaches of lease. All those don't have on it a moratorium on the execution. Now, the impact that we might see, and this is to be determined, is whether or not this COVID-19 hardship defense could be used for any existing evictions that are in the pipeline. So when we got shut down back in the middle of March, there were many landlords that had pending lockouts that were due to take place the next day within the next week.
Yeah.
Will those apply the new statute and the moratorium? I don't know. They're not COVID-19 related cases because they're already in the pipeline. However, when you read the statute and a tenant has the automatic right of redemption to pay in full prior to the time that they're locked out, and now they can't pay because of a COVID-19 related hardship.
I'm getting you.
If we have a very liberal interpretation or a judge that is very liberal, it could be stretched. I don't anticipate that being the case because by the time we get back into court, we're talking July at the earliest, August being more likely the time, and someone's lived for 8 months free. I don't know how much leniency a judge is going to provide unless it's extreme circumstances. So as far as the August 20th date and the extended moratorium on warrants being executed, more than anything, minimal impact. Landlords should not be concerned about. Quick update on some stuff we talked about last time. I had one of my dates wrong. I counted incorrectly. The CARES Act has a 90-day moratorium on foreclosures and a 120-day moratorium on the service of any pleadings in a eviction proceeding. I had said June 20th. I had my dates mixed up, and I apologize for that. It was just a clerical error in my head. So the CARES Act that President Trump signed into legislation put a moratorium on serving pleadings. And we talked about last time the impacts of that. The date's July 21st. If you have a mortgage that's federally backed by Freddie Mac, Fannie Mae, Sonny Mae, VA, FHA, anything federally funded, we need to be particularly careful of serving any non-payment notices or any notices of any kind prior to July 21st. So that's to be taken, fairly serious and closely looked at before doing anything. And you certainly don't want to be in violation of the federal law because that has a lot more teeth than anything else possibly could imagine.
I got a question on that real quick. So should we have, is there going to be like an addendum the client signs saying that they don't have one, they haven't refinanced into one? How are you going to handle that?
Well, right now, since things are only trickling in my personal law practice, I just ask the question over email, and sometimes I get lucky. Oh no, I own it outright. There's no mortgage. Other times I hear, oh no, it's just a commercial loan through Trustco. But you can never be sure. Anything short of me actually looking at the document, it's difficult to draw the conclusion that it is or isn't federally backed. It's not that I don't trust clients.
They might just not know.
They might not know. And if the legislation extends all the way down to me, and I could be potentially fined if I am attached to it or involved in any way, because obviously the attorneys have, a fiduciary responsibility.
Yeah.
And they're probably historically seen as someone that you can sue easier, whether it be because of liability insurance or deeper pockets. I don't want to take the risk. I don't want to take that risk, nor should you take that risk, or any landlord listening should take that risk without reviewing it and being 100% positive.
So but somebody could say they don't have it, and then you look at the note mortgage, but they refied and they didn't. You know what I mean? They don't even remember they refied it back then, or they got 20 mortgages. So
that's right. You got to see it. So my rule is I have to, if it's before July 21st and someone's asking me personally to do something, I'm making them show me the document. Just telling me or even signing a waiver, I don't like the idea. I mean, I could draft up a waiver, but just because I'm indemnified because they're signing a waiver, that doesn't prevent someone from suing me. Now I'm in the lawsuit. It's still my head.
Yeah.
So I need to sue
you. Yeah, the tenant's suing you or the government's suing you. Got it, 100%. All right, so we'll just know that going forward with our stuff. We'll have to talk about that out, before we do this. But all right, that's cool.
And the other thing that I think is worthy of mentioning is courts. When are they going to reopen? People keep asking this. And in addition to being a private practice attorney, I also serve as a member of the town board for the town of Colony. And we've had a lot of conferences in the past weeks, budgetary reasons, naturally. And I've been working closely with our judges there. thinking, well, how's this going to work when we reopen? And so I have some insight on that. And particularly when the governor gives us the okay to start opening back up, it's going to be a phased in process. Initially the staff is going to be allowed back in without any public being able to go into the buildings. And during that initial period, 1 to 2 weeks probably, they will get caught up in all the notifications to people when they need to be back in the court, because that stuff has to get out. A certain time period has to elapse in order to receive it and process it and respond to it. Then the old cases that were in the pipeline, they will be heard. That's probably also a good 2 week, if not more, period of time. So we're looking out, in my opinion, easily 4 or 5, as many as 6 weeks out before the courts will be able to handle any new cases. So if we open up June 1st, I don't think new cases are going to be even able to be heard until the middle of July, strictly because of logistics.
Yeah.
Once we are able to hear new cases, and even some of the old ones in the pipeline, the issue also is with social distancing and how much volume or crowding are we going to permit in the courtrooms. Some of the business courts, which I attend, as you're well aware,
yes.
Troy, Albany, Cohoes, there's a lot of people in there on court days.
Mm-hmm.
And that's going to be problematic, because if everybody has to be 6 feet apart, which is obviously going to remain the standard, and maybe even no more than 10 people in a court at one time, that's going to either A, slow down the amount of evictions we can do, or it's going to push them out farther. I don't know how the court's going to treat it. I don't know if they're going to just take less people on a particular day, assign different times throughout the day, or just it's going to take longer. And that's bad news for landlords, because the longer it takes, usually it drives up the cost, So that's just a little bit of writing on the wall that I've been piecing together over the last couple of weeks that concerns me. But we're all in it together, and we're all going to have to try to make a conscious effort to get out of it together.
100%. Yeah. Screen your tenants, I always say.
Oh my gosh.
Try to avoid. It's more important than ever. Screen your tenants. So June 1st. What are they saying? Do they think it's going to be June 1st, or it's still so up in the air and nobody knows yet?
Well, I think part of it, we have a couple different bodies of guidance here. We have the various counties that can reopen once they've met the governor's 7-point test. So certain counties might be able to open before others, but I don't think the chief judge in this area, the 3rd district, I think it's going to be everyone's going to open up at one time. So I don't see that happening until at least June 1st. And then, of course, there's going to be a phase-in period for the staff before the public, because there's going to be a lot of other types of issues that have to be addressed as far as cleaning the courtroom, sterilizing the courtroom, how we handle things. Everyone's going to have to be trained, and it's going to be a real nightmare, in my opinion.
100%.
We're going to have to wait for some further instruction there, but there's definitely, in my opinion, going to be a reopening in June, and then we should be able to resume normal activities by July sometime. But it's going to be a little bit of a long haul still. I mean, people are going to be frustrated.
Yeah, 100%. So, well, look, David, I appreciate you coming on, clearing up a few new things that came out. Anything else you want to say before we get off here?
No. I think we covered all, but I do want to stress that August 20th date's not to be concerned. You shouldn't be concerned with it, overly concerned with it, because I don't think the practical impact of it is going to be anything at all once things kind of gear up and start going again. And landlords should be looking at holdovers as a mechanism for getting people out more so than ever, rather than a non-payment, because I think there's going to be a lot more defense to the non-payment. So
what about violations? What about, violations, right? What about violations?
So violations are a difficult eviction to pursue, because you have to follow the letter of the lease first. So you have to read the lease and see what actually is a violation, how you treat the violation as far as, do they have the ability to cure? Do we have to put them on notice? Do we have to do a second notice if they didn't cure it? So you have to read each individual lease first to see what the procedure is, once you've made a determination that there's a lease violation that is actionable, and you set the stage with the various notices, then when you get to court, you really have to ask yourself, is this something that if the tenant denies outright and isn't willing to cooperate, that we can prove? Okay. If it's, hey, multiple people in is crowding, that's tough to prove. If it's, they have animals, that's tough to prove because they could say they were dog sitting. If they were smoking, they could say, no, I did it outside. It just happened to come in. So unless you have concrete evidence like police report or a conviction or testimony from another tenant or video surveillance, they're tough to be successful on. You have to be able to frame it and you have to be able to prove it. And so holdover is a much better alternative. Hence, month-to-month leases or shorter-term leases are great. Better tenant screening, of course, is something that you always want to consider. But at the end of the day, it's a more difficult eviction, more time-intensive, and less likely to succeed.
So we got one right now where it's super rare, but these tenants just haven't paid, and it's very rare. But I think maybe the person, I don't know what happened. They brought a dog in. The dog is not legal. The insurance company actually seen the dog when they're doing their inspection in the basement. So they want to cancel the insurance. Not only are they not paying, they're just horrible, never paid ever before COVID. And then they have a dog on top of it that's not allowed by the insurance company. So now the insurance is in jeopardy as well. Would you send a letter to them saying, hey, look, you're in violation of lease, and then do it as a holdover that way? Or how would you handle that one?
Yeah. First, I would look at the lease agreement to see what provision of the lease they're violating.
Yeah.
There's a lot of standard language in leases that indicate that if you're any other breach or anything that's objectionable, obviously this would be objectionable, and for the reasons you just cited. Excuse me. So I would initially put them on notice to cure it. There'd be usually the leases call for 5, 10, maybe as much as 14-day period to cure whatever the action is. A lot of my community clients, my institutional clients rather, it's 10 days. So I issue a 10-day notice saying you're in violation of this provision of lease agreement and management's aware of it. We need it to be remedied within the next 10 days. Otherwise, we're going to terminate your lease. So during that 10-day period, if it's taken care of, great. If it's not taken care of, then we have to hit them with another letter that's saying the violation has continued, and certainly you better have pretty good proof of it if you want to go down this road. And therefore, we're terminating your lease at the expiration of 3, 5, whatever the lease calls for. It's usually about one. A lot of them are 6, actually. A lot of my institutional clients, it's 10-day notice to cure and then a 6-day notice to quit if they haven't cured it. And then at the expiration of the 6 days, it's treated like a holdover because the lease is terminated. But then there's more defenses to this type of holdover action. The defense is, hey, I didn't do it. They didn't have a right to terminate my lease, and you can't prove it. And going to trial in a normal year is challenging because it takes time. Now it's going to even be more challenging because I don't know what time the courts are going to have to even do it. So we want to set the stage for a better likelihood of success. Doing objectionable tenant holdover breaches of lease is tough. I try to run the other way. I try to instruct all my clients do month-to-month or shorter-term leases like 6 months so we can get them out on just a standard 30, 60, or 90-day notice, depending on how long they've been there, and deal with it that way. It's tough. It's tough. Okay. Not to mention cost.
Yeah, I got you. So with that one, you would just stick to non-payment because they're going to be like 5 or 6 months behind at this point.
Well,
that was a penny paid.
The lease must be due to expire.
No, because it started early. It started early in the year. So I think
you're about 6 months into it right now.
Yeah, we'll be 6 months in. By the time court opens, we'll be 6 or 7 months in. They just didn't make a payment. I think something happened to the woman that rented it is what I think. I think something happened to the woman.
And this is their first year there. It's not like a renewal lease.
It's a brand new lease. They never made another payment. They moved in, never made another payment, which is so rare.
And it's for a year period, the lease?
Correct. Yep.
Right. Well, I guess your only option, you could do it twofold. You could, upon reviewing the lease, you certainly could issue the notices for violation and to cure it. But you could also obviously want to do the non-payment 14-day notice, and then you see what sticks. You can never bring two causes of action on the same date, but you can stage them. You can do the non-payment first, and if you're successful, great. If you're unsuccessful, then you're going to go for the other. And if you kind of serve the notices all around the same time, it gives me in court, if I'm the one representing you, a little bit more leverage or ammunition to discuss and try to work something out with the tenant. Say, hey, look, you know, we just don't want you there. It's not working out. Nothing personal. We got to move on from this relationship. You know, I'll give you 30 days. You know, you try to work something out that end. You know, going forward, the cost is going to be too great. So again, it's kind of like cash for keys. But this, if we get them into court, then we got the warrant to back it up.
Yeah, this is so rare. I think, like I said, the woman worked like at Albany Med or some hospital locally, and she made like 60 grand a year. And so I don't know what happened. We've never spoken to the woman. Some guy showed up. So who knows if it was a smooth talking dude that got some girl to get it for him, and she just was an A+ person until she met this character, or they got on drugs. Who knows? But it's a bad situation. And then COVID didn't make it any better.
Right.
So, and it's so rare for us to run into a problem like that.
It's rare for you, Brock, but believe it or not, I get that scenario with a lot of my individual clients that don't have property managers. That happens quite a bit.
Yeah, I mean, it hurt. It made me almost vomit. I was so mad about it. You know, it just because it never happens. Such a rare situation for us. Like we don't normally get bait and switches like that because we vet them so well. But all right. Well, anyways, look, I appreciate it. Appreciate your time today. I know you're a busy guy, so appreciate your time. Thanks for coming back on. We'll put all this together so people can see it. And thanks again.
Hey, thanks for your time. I appreciate the invite.